So welcome everybody. We're so excited to have you in class today. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center. And today we're going to talk all about the Bill of Rights. And I'm here with one of our top scholars, Tom Donnelly. Tom, how excited about the Bill of Rights are you today?
I am very excited.
So Tom, to make this really fun and engaging, we're going to kick off a really simple quiz on the Bill of Rights that's set up by Kahoot right now. So our students log into your Kahoot. This is going to be fun, fast, and furious. And if you get any answers wrong, don't worry, you're not being graded. This is just for fun. And we're going to talk about all these amendments in a little bit. So let's get started. And Tom, as we go through, feel free to add commentary to the answers.
Will do.
And all students who are doing this at home, there's a fun music quiz that goes, or music sound that goes along with this. So how many amendments are in the Bill of Rights that was ratified in 1791? Were there 8, 12, 10, or 15? We like to thank you, Warren. If you don't want to play the Kahoot and you want to answer in the chat, you can do what Warren just did. And Warren, you are right, of course, one of our star students. Very good. So the answer is 10 amendments in the Bill of Rights that was ratified in 1791. Tom, 2 people picked that kind of brown yellow color at 12. Why is 12 a significant number for the Bill of Rights?
Well, at the time, we sent 12 potential amendments to the states for ratification. And in 1791, they only ratified 10 of them.
So you get half credit for that one, we're going to say. So next question, who is the primary author of the Bill of Rights? Which one of these guys? Was it Thomas Jefferson, Alexander Hamilton, James Monroe, or James Madison? So again, feel free to answer in the chat. Warren, you're again correct. But also, if you want to use the Kahoot, which one was the primary author of the Bill of Rights? James Madison is correct. Lots of people picked out Thomas Jefferson. Why, Tom? Why would people think, and I get it, I totally get it. So why is Thomas Jefferson usually a picked answer for the Bill of Rights?
I think because he's the author of the Declaration of Independence. Of course, it's a very good answer because Jefferson himself was important to convincing James Madison that the Bill of Rights was a good idea. So partial credit for that.
Awesome. There's the pin in the chat again, just for newbies, and I'll make sure you can see it. Okay, next question. Which right isn't guaranteed in the First Amendment? So First Amendment has 5 freedoms. One of these is not one of those 5. So in the First Amendment or another amendment, which one is not in there? Freedom of speech, freedom of the press, freedom of assembly, and the freedom to bear arms or the right to bear arms. Which one is not in the First Amendment? Very good. Not in the First Amendment is the freedom to bear arms. So Tom, 2 questions. What amendment is that in? And then what are the other 2 freedoms that are in the First Amendment?
Sure, the right to keep and bear arms is the Second Amendment. And then the last 2 rights in the First Amendment are freedom of religion and the freedom to petition.
Awesome. Next question, and we will look at the winner at the end. And we're all winners because we're all learning, which I know is the worst statement ever. What is the Third Amendment all about? This is for Scott. We're shouting out to Scott here. This is his favorite amendment. So is it about soldiers occupying your home without your consent? Is it about the right to privacy? Is it about your right to an attorney? Or is it about your right to a trial by jury? Very good. The answer is soldiers occupying your home without consent. But we're going to give a special nod to the people that answered the blue color, the right to privacy. Tom, why?
Well, because part of the concern with the Third Amendment there is to protect the privacy of your home, your private property. It's about the integrity of those things.
So it is about not having soldiers in your home, and that is in some way privacy of your home. Okay, next question. Does the original Bill of Rights protect you against cruel and unusual forms of punishment? So students, somewhere in the Bill of Rights, those 10 amendments that are added in 1791, is one of them about cruel and unusual forms of punishment and protecting the individual from it? Warren, if everybody could see your answer. Yes, 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 yes. Good job, the class as well. Very good. The answer is yes. So Tom, which one of the amendments is about cruel and unusual punishment?
The Eighth Amendment.
The Eighth Amendment, yep. Okay, next question. Does double jeopardy, self-incrimination, and due process are all critical parts of which amendment? I'm going to give you a hint on this one. If you need a hint, think about when somebody says, I'm going to plead the, what's the number? That's my big hint. Very good. Plead the fifth. So that would be self-incrimination. Tom's going to go over this in a little bit because there's a lot more in that Fifth Amendment. There's a lot packed in there, Tom. What's your favorite part that's not listed?
Well, the takings clause is important, and that's not listed. It's all about property rights.
Awesome. So you can't take somebody's property without the appropriate measures. So question number 7, the original Second Amendment wasn't ratified in 1791. It later became the 27th Amendment. How long did that process take? So it technically wasn't the Second Amendment as we know today. It would have been the second article. It could have been the Second Amendment, but it wasn't ratified till years later. How many years later was it? 10, 50, very good. Right answers, 2003. Tom, which amendment was it? So it was a part of that original Bill of Rights package, but didn't get amended to 203 years later. Which amendment is it, and what year was it ratified?
So it's the 27th Amendment. It's ratified in 1992, and it limits Congress's power to raise its own salary.
Big. Madison wrote a good one that really stayed the course. James Madison's home state, Warren better get this one right, made the Bill of Rights official when it ratified it in 1791. So the last of the 9 out of 13 to ratify it. Which state is that? New York, Connecticut, Virginia, or Maryland? So where is James Madison from? And what did we say? 7 or 8 of the presidents are all from this state as well. Very good. Virginia is the correct answer. Okay, next question, and we're wrapping up here in a second. Where is the original federal government copy of the Bill of Rights? So many words in this one on purpose. The original federal government copy of the Bill of Rights, is it housed at the National Constitution Center, in the Senate Rotunda, at the National Archives and Records Administration in DC, or in the Oval Office at the White House? It's kind of a trick question. Very good. It's at the National Archives and the Records Administration in Washington, D.C. But we will give some extra points to those of you who picked the Constitution Center because we actually do have an original copy of the Bill of Rights. It's one of the originals that went to the states with those 12 articles listed on it. So if you're ever in Philadelphia, come hang out with us and check it out. It's a really cool document. And I think this is one of our last questions. We're almost there. Okay, the 10th Amendment deals with the relationship between which two groups? Is it Congress and the president? Is it the federal government and the state governments? Is it the Supreme Court and the military? Or is it United States and Canada? Always makes me want to laugh when I say it. So which two groups? Very good. The 10th Amendment's all about that relationship between the federal government and the states. Really, really important. And last but not least question, here we go, and then we'll see who's the winner. The original Bill of Rights covered abuses by whom? The national government, the state governments, or both? The national government and the state governments. This is a tricky one, but think about how the First Amendment starts. Who shall not make? Warren, you're saying both. Warren's guessing both in the chat. The rest of the students guess the national government. Tom, who's right?
The national government with the original Constitution, and then it's later with the 14th Amendment and other Supreme Court cases where we extend it to cover the states. Of course, John Bingham would agree with Warren. He thought it always applied throughout, but yes.
Yes, and that I think we talked about earlier in the week is that if you went with the Bingham, he would have said all the way through. And if Madison got one of his amendments put in. So Emily, good job for winning that round. And with that, let's dive into the history of the Bill of Rights, Tom. We think about this Bill of Rights, and so often many Americans, when they talk about the Constitution, name one of the amendments in the Bill of Rights. It's so valued and important to us, but it's not in the original Constitution. So all my questions around why, where did the ideas come from? Were they like handed down, from divine intervention? Where are the original ideas come from? And then why didn't they put it into the Constitution in the beginning? So where do you want to start? In the history before the convention, at the convention? Your choice.
Let's start with the history before the convention. And the one thing I'll even preface that, but that part of it with Kerry is, it would not have surprised Madison that we wound up listing the rights in the Bill of Rights when we thought of the Constitution. And in fact, he would have been absolutely delighted by that. Because for him, one of the great values of the Bill of Rights was that it would educate the people. It would remind the people of their most important, their most cherished liberties. And so over time, as government acted, we, the people, would think back to the rights enshrined in the Bill of Rights and often compare the government's actions to the promises in there. So there's a way in which in those very answers, we're carrying out one of Madison's visions for the Bill of Rights. But you're right, Kerry, where do these rights come from? It feels natural and inevitable that we'd have a Bill of Rights and the Bill of Rights would list many of the rights that are in there. For the founding generation, the thing to remember about them is that they were children of the Enlightenment. And so by that, I mean that what they tried to do is they tried to learn from history. They tried to learn from their own experience and pull ideas from both of those sources to try to really make good decisions, to try to sort of pull the best lessons, the best ideas from prior experience. And so when we're looking at the rights that end up in the Bill of Rights, there are two key initial sources we can think of that come from before the Constitutional Convention. One of them is English history. And so remember, the founding generation, when they carried out their revolution against the British Empire, one of their great complaints was that they were entitled to the full rights of being English people. And so with that would come the rights enshrined in key constitutional sources in England, like the English Bill of Rights. And so from their perspective, one of the great abuses of the king, royal officials, parliament was the fact that the English did not respect the rights of Americans, many of these rights deriving from these key sources like the English Bill of Rights. But also for the folks at the convention and those in the first Congress that put together the Bill of Rights, they were also thinking about their state's constitutions. Because even before we had the US Constitution, we were governed by 13 different state constitutions. This was the first big act of constitutional creation in America. And so we had leaders in various states putting together frameworks of government. And as part of those frameworks, many of those constitutions had declarations of rights or bills of rights. The most influential is the one you see on the screen here, which is the Virginia Declaration of Rights. But so when James Madison is sitting there in the first Congress thinking, what rights do I need to put in a Bill of Rights for the US Constitution? He's drawing on both these English sources, but also key sources from America, like the Virginia Declaration of Rights, which was authored by his fellow Virginian, George Mason.
So it's amazing to think of like these listings of rights, these writs of rights. And I almost want to do an activity with our students, like, what would you list if you only had 10 spots? What would you add to there? But, there's no need to limit them. But, at the convention, they walk in knowing that the states have these listings of rights, these Bill of Rights. And they walk into the convention and their big charge is to set up a structure of government. And so they get to the end of the convention, they don't have a Bill of Rights. Is it because the states already have them that they're not worried about it? Or is it because they don't think it's needed? Like, what's the reason behind not getting to the Bill of Rights, and doing it just 4 years later?
Yeah, I think part of it, Kerry, is, for certain delegates, I think Roger Sherman of Connecticut talked about this. Like he thought, well, we do have state bills of rights. That's going to take care of a lot of our rights. Some argue, just as you said, Kerry, which is that the national government is a government of limited powers. The new national government doesn't have the power to do things like abridge the freedom of speech or religious liberty or gun rights or what have you. And so that structure alone is enough to limit the power of the national government. But there's also just the practical. And in many ways, I think this may be what's going on, Kerry. They're sitting there in a hot, smelly summer in Philadelphia. They're there for 4 months. In under 100 working days, they've set up a whole new structure of government with a Congress, a presidency, a new judiciary. And I think at that point, they're like, haven't we done enough? Can we please go home? And so just try to place yourself in their shoes. There is undoubtedly that human element too.
I think, and I'm cracking up over here because we do 233 years later, we put a lot of pressure on these guys. And we're like, you didn't do enough. I feel like the bad like grandparent, like you need to do more, kids. You need to do more. But you're right. You're totally right. They're there. Most of them, a lot of them are there from early May. And they're there all through May, all the way through to September 17th. This is at the Constitutional Convention signing. And it is, you're right, Tom, it is hot and smelly. Philadelphia was not known for being clean at the time. We definitely had waterway issues with a lot of pollution. So it's like straight up smelly, like he's not kidding. So and they get so much accomplished. They set up a government, they set up this constitution. But how quickly are the calls at the end of the convention and then begins to start ratification for a Bill of Rights to be added? Are they right away, or do they take some time to get through?
Yeah, I mean, let's start at the convention itself. So it's the closing days of the convention. And who's in the convention but the author of the Virginia Declaration of Rights, George Mason? And so he says, look, we've done great work, but we're missing a Bill of Rights. And you know what, fellow delegates, you are so lucky because you have Mr. Bill of Rights right here. I wrote the Virginia Declaration of Rights. Give me a few hours. Give me a couple of days. We know what needs to go in there. I know what needs to go in there. Let's put a Bill of Rights in here. And he said that this will, quote, give great quiet to the people. He anticipates that if we don't do it, this is going to be one of the things that opponents of the Constitution point to. Why? Because so many people, as they're looking at this new Constitution, once it becomes public, they're concerned about a new national government with a ton of power. We had an old government, the Articles of Confederation. It was very weak. The whole project of creating this new Constitution was to create a more powerful national government. The concern here is that maybe we've made the new national government too powerful. Maybe there's a danger of the new national government abusing our rights. What better way to address those legitimate concerns than to add a Bill of Rights? But no one takes up Mason's offer. And so we end up with a Constitution without a Bill of Rights. And then we'd have our three dissenters, Kerry, George Mason, Edmund Randolph, and Elbridge Gerry at the end of the convention saying, no, we're not going to sign this new Constitution, in part because it didn't have a Bill of Rights.
Yeah, and it's really fascinating to think about, like, putting yourself in the mindset of the founding generation and the people of the country, just fought a war and going through all this turmoil. Who are they most worried about? And they're most worried about this big national government stepping on individual rights. And so that is the big fear. Yet this idea that the government itself would check itself, that's also talked about a lot. So, and I love this image of the dissenters. So everybody knows that this is our room at the Constitution Center. It's called Signers Hall. And this is the back corner where the three dissenters are hanging out looking very annoyed. And I love it because they totally look.
I think Elbridge Gerry was always annoyed, honestly.
We do have a really fun quiz that you can play to see who you're like. And if you're a curmudgeon, you usually get Elbridge Gerry as your personality type. I love it. It's actually pretty accurate. But they come to this with this, we have to be careful. We still have given too much power. But the other side is saying, nope, the system will check itself. And that's something Colin shared in the chat. Hamilton thought federalism and the systems of checks and balances would be enough. So do we want to talk about the counter argument? So if these guys are saying we need a Bill of Rights to protect the individual from this big government you just created, what's the counter argument?
Sure. Yeah. So, I mean, the other thing to note is that the arguments made by the dissenters are then picked up by the anti-federalists when we're battling over the ratification of the Constitution. So the anti-federalists, those who oppose the Constitution, they would end up saying, echoing a lot of these concerns about no Bill of Rights. Part of it was a concern about individual rights. Part of it too, Kerry, was a concern that this national government was going to take over the powers of the states. And so take away the very power of self-governance that so many Americans really associated with their state governments. And also the anti-federalists would provide a lot of specific advice. So you'd have these dissenting reports from different conventions saying, these are the rights we think should be in a Bill of Rights. And so, you know what, if you take care of this, maybe we will go on and support the Constitution. But you're right, Kerry, the Federalists had their own principled arguments. And Colin, you point to one of the really important ones where, Alexander Hamilton, James Wilson, even James Madison were skeptical of the need for a Bill of Rights. Hamilton provides one of the strongest arguments in Federalist 84, and it's exactly what Colin said. The idea is that the Constitution itself provides something like a Bill of Rights in its structure. We create a government of limited powers. We list those powers in the Constitution. If those powers aren't in there, the national government doesn't have them. Simple, full stop. Furthermore, we write in separation of powers, checks and balances. These structures keep us safe from the national government getting too much power and therefore abusing our rights. So structure itself can take care of some of these concerns. The other, and in many ways, Madison provides this in the strongest way in letters with Thomas Jefferson. As they're discussing the new Constitution, Thomas Jefferson, James Madison's great friend, is saying, Mr. Madison, James, my great friend, the Constitution, it's all right. I have some problems with it. But where in the world is the Bill of Rights? That's a huge problem. To which Madison responds, you know what? Let's think about this. A Bill of Rights can't do everything we want it to do. There are dangers once you begin listing rights. Two of them spring immediately to mind to Madison. One, once you list rights, you're not going to be able to list all of the ones that the people actually have. And so are you going to end up having a list of rights that's short? And by listing them, you then disrespect the rights that aren't listed. So therefore, it may appear to be the case that the people have fewer rights than they actually do. The other is that even among those rights that you choose to list, once you list them, once you write them down, they will automatically become more limited than they really are in reality. That words can't capture the breadth of the rights that the people actually have. And so those are two great dangers, to which Jefferson replies, okay, maybe there's something to that, but is it really, really going to hurt to list some rights? You know, we already don't really trust this new big national government. Maybe we're only getting half a loaf. Maybe it's not going to totally work, but isn't it better to err on the side of rights protection versus not? And ultimately, Madison ends up acquiescing. But those are the series of arguments the supporters of the Constitution are giving back to the anti-federalists, as the anti-federalists are saying, no, we can't have this new Constitution, in part because it has no Bill of Rights.
So, and I also think Jefferson was probably a little upset that he just wasn't, there and involved with all these pieces. So it could be a little of that, just saying with Jefferson. Great question from the Esberg class. So were there two popular political parties like Democrats and Republicans at the time, or were there just Federalists and anti-Federalists? Kind of how was this set up when we're thinking about the political structure at the time?
It's a great question. No, I mean, it kind of predates what we would think of as modern parties. I would say there's a lot more cohesion, a lot more unity among the Federalists. So a lot of them were working together before the convention to try to get a convention and a new government, and then would work together in an organized way towards ratification. The anti-federalists, there was some coordination, but it was much more scattered. And you also saw a greater range of arguments based on, frankly, where people stood in society, whether they were the elite, part of the middle class, or even part of just agrarian rural people who were very far away from the centers of power.
Fascinating. Okay, so Madison finally comes around and says, okay, we're going to do a Bill of Rights. Is it because the Constitution's not going to be ratified without it? What are some of the underlying reasons that Madison comes to the table and says, you know what, I'm going to get on board? He's considered the father of the Bill of Rights, even though we know there's a lot that he takes from Virginia. But why does he get behind it? And then I want to walk through all those amendments and see what's in the Bill of Rights.
Well, that's great. I mean, I think there are a few different reasons why James Madison ends up being the father of the Bill of Rights, although he begins as a bit of a skeptic. I mean, one, I think, Kerry, is that his argument over the Bill of Rights and over ratification is a great early example of the value of dissent within the American constitutional system. And that I think that James Madison legitimately heard the concerns the anti-federalists were expressing and took some of them on board and altered his views to a certain extent. Part of it was a function of politics, Virginia politics. Patrick Henry, very powerful Virginian, opposed the Constitution, was angry at James Madison, had power and sway over the state legislature, so Madison couldn't get a seat in the US Senate. Madison had to run for the US House of Representatives in the first Congress. He wound up running against James Monroe, the war hero and future president. And Madison heard from his constituents, we really want a Bill of Rights. And so part of it too was Madison's connection with his constituents, and that he wanted to be elected. The last one, Kerry, and in many ways, this may be Madison's greatest insight, is that he took seriously where we stood in the American project. We were beginning a new constitution, a new government. And what he thought was, it's really important that we take dissent into account. And for those people who are people of good faith, who love America, but have certain concerns about the Constitution, are there certain things we can do to make them feel better about the new government? So as they continue to dissent, they do it within this new framework of government, not from outside. And so, in those first elections, the Federalists win the presidency and Congress, et cetera. They could have ignored the anti-Federalist concerns, but Madison understood the importance of bringing those folks on board, and it would be very important to the success of the American project.
Yeah, I think that's fascinating about like folding it in. And I also think like I always crack up that the dissenters stayed and protested. So they did like the action of the First Amendment in the Constitutional Convention. I want to walk through kind of the big ideas of each one of these amendments, but I also want to kind of shout out to Emily's question in the chat. In a way, isn't that what happened though? Like the Supreme Court only respects rights that are listed in the Bill of Rights and other amendments to the Constitution. Was this a fear that the Bill of Rights would only serve to limit rights actually well-founded? So as we look through these amendments and try to go through those pieces, I wonder, what are the other protections that we see the courts upholding that aren't spelled out in here too? So now I just added two things to your plate. Explain what it is and explain what is like incorporated by it, but not spelled out.
Yeah, no, I think one, I'll just say that's a great point. And I do think we do see plenty of dividing lines in constitutional debates over to what degree we are limited by what is specifically listed in the Constitution versus rights existing beyond that. I mean, the classic example of a right that's not specifically written in the Bill of Rights, but that is later recognized is the right to privacy. That would be there are ways in which you can squint and say it's implicated by certain amendments, but the right itself, broadly speaking, is something that extends beyond what's listed. But I'll sort of keep that in mind as we walk through the other rights.
I just like to add to your list of to-dos.
Yeah, of course. So let's walk through very quickly, get to the big ideas in each amendment. The First Amendment, as we already said, combines 5 freedoms: religion, speech, press, assembly, petition. These all go to the big idea of, in many ways, of freedom of conscience. Religion really has, the freedom of religion has 2 parts. It keeps the government from being able to establish a religion. It also protects our right to free exercise, so to believe or not as we like. The freedom of speech and press expresses the American commitment to broad free speech rights, the idea that we're able to say quite a bit, that we're able to criticize our government, and that this is seen as the core or one of the cores of the American system of government. And the one thing to note is that today, free speech rights are broadest in many ways in the United States, and the free speech rights as expressed by the Supreme Court are broader than at any other point in American history. And the key rule now under free speech is that we will generally allow people to speak as long as their speech is not likely to to cause immediate lawlessness. So it's a really, really broad free speech protective rule. Assembly and petition really go to rights that people without political power use to try to express political power. And so this has been used especially by people who have not had the right to vote. So women, African Americans, and then also unpopular groups like the abolitionists in the 1800s. This is a way for those without power to speak to those in power.
Awesome. Now, next to the Second Amendment, and everybody, I'll drop some copy into the chat as well, so you can kind of read it as Tom goes through it, because I know we're going fast. So Second Amendment, what's the big idea of the Second Amendment, or a couple big ideas?
Yeah, so there are 2 parts to the Second Amendment. The first part speaks to the relationship between gun rights and the power of all of us to join as a militia, as a community, to defend our government. So that's a right associated with the militia. The second part speaks more to an individual right to keep and bear arms. And the way that the Supreme Court has now interpreted this is that at the very least, the Second Amendment does protect an individual right to keep and bear arms to protect your home. So there may be reasonable regulations outside the home. Those are contested questions of constitutional law. Under the Supreme Court's decisions, though, there is at least a core individual right to protect your home.
And the Third Amendment?
So the Third Amendment is protecting us from having to house soldiers in our house during peacetime. This grows out of the colonial experience of the British Quartering Act, where royal officials required American colonists to house British troops. And we said, no, not in America.
Then nice and easy. Fourth Amendment, one of my favorites.
So the Fourth Amendment, we're getting into now a series of amendments that protect those suspected of and accused of a crime. So the Fourth Amendment goes to the protection of a certain set of things: our persons, so ourselves, houses, papers, and effects. And what it protects us from are unreasonable searches and seizures by the government, most often by police officers. And the big idea here, Kerry, and it's connected to the warrant requirement, needing to get a warrant before doing these things, is that the government needs a really, really good reason to do these things, to either search me, search my house, search my papers, my stuff. It has to be particular to me. There has to be a good reason that they suspect me of a crime. It's not enough to just generally think, yeah, maybe he did something. No, you need something specific and strong.
Yeah, and I think that's always the best part about the Fourth Amendment is like, can they do that? You have to have a good reason, and you have to be supported by somebody else to really invade that your stuff in your home and your thoughts almost in a way. Fifth Amendment, there's a lot packed into the Fifth Amendment.
Yeah, so the Fifth Amendment does a ton. It has a few more things that have to do with the rights of the accused, like the right to a grand jury, the right against self-incrimination. So this is your right to remain silent. That's here. When you plead the Fifth, you're pleading the Fifth Amendment. The right against double jeopardy, so not being convicted of tried and convicted of the same crime twice. And then there are a couple of broader protections at the bottom. One is the protection of due process of law. So the government can't deprive you of your life, your liberty, or your property without due process of law. This speaks to broader concerns about fairness, fair procedure. And then finally, that last part is the takings clause, which says that the government can't take your private property without paying you a fair price for it. And they have to be using that property for public use. They can't just take Kerry's property and give it to me.
Yeah, and I always find it, and it has to be for a really good reason too. They just can't take the property. It has to be for like a societal reason. Sixth Amendment, which I always think about this, is how we put fairness in the criminal justice system.
That's exactly right. Fair procedures in criminal trials, because we want to make sure if we're going to convict someone of a crime that they got a fair procedure and could put their best case forward. So with this comes a right to an impartial jury, a speedy public trial. The government has to tell you what it's accusing you of. So that's the right to be informed of the nature of what you've done. You have to be a right to confront your witnesses. So this is the right to cross-examine those who are coming out against you. You have to have a right to be able to call your own witnesses, so the government can use its power to say, no, you witnesses have to come to court and testify. And then finally, a right to counsel. And again, all of these things are about both making sure that you have a fair jury that's hearing your case, a jury of your peers, people like you, not just government officials. But also all of these other things will give you rights that allow you to make your best case.
Yeah, and I think it's, when we think about these words, it's not always, and this is kind of to Emily's point, it's not always what's written down. It's to ensuring that people fight to make these words real. So when I always think of, Warren shared Miranda, I always think of Gideon when I think of the Sixth Amendment and looking at the Seventh Amendment too.
Yeah, the Seventh Amendment now extends the right to a jury trial to civil cases. So these are, broadly speaking, civil cases just mean cases that aren't criminal cases. So they can involve money, contracts that are broken, claims. Basically, it's cases that involve you against someone else, you against a business, two businesses against each other, us against the government, all of these sorts of things. And it's just to assure, again, that you're able to make your case before other people like you and not to some government officials.
And then the Eighth Amendment, another fun one for all the students to talk about.
Yeah, so this, broadly speaking, it prevents the government from imposing cruel and unusual punishment, excessive bail, excessive fines, and all of these together, they go to the concerns, especially the anti-federalists, that a new powerful national government was just going to invent new crimes, invent terrible new punishments, and use that to oppress the people. They thought that this was the experience that England saw with many of their kings, and we wanted to avoid that happening here, and so wrote that protection into the Eighth Amendment. And
I think what I love about the Eighth Amendment is it's like morally set, because like what you define today as cruel and unusual punishment is it maybe what you would define 30 years ago as cruel and unusual punishment. So I think that's why I think it's an interesting amendment, because it has like flexibility in there.
Yeah, that's often what a lot of the constitutional debates are over, is how much flexibility there is, actually.
Yeah. And then the catch-all amendments, 9 and 10. This is like to safeguard what they were writing, to ensure that that fear of if you don't write it down, it's not listed, doesn't happen.
Yeah, that's the Ninth Amendment. Totally, Kerry. It's responding to that concern. It's some scholars say it's a recognition of natural rights in the Constitution, but I think more broadly speaking, it's sort of a rule of how you should interpret the Bill of Rights itself. And it says that just because a right is not written in the Bill of Rights doesn't mean that it does not exist. There are rights that may exist beyond those that are listed in the Bill of Rights. And so it's getting at that Madisonian concern we talked about, that once you list rights, the ones you leave out are going to be disrespected. The Ninth Amendment is saying, no, don't disrespect those rights.
And finally, the 10th Amendment.
Yeah, the 10th Amendment goes to protecting the traditional power of the states. Because remember, at the founding and all the way through much of American history, so much policymaking happens at the state level. States have the power to pass laws that protect the health, safety, welfare of their residents. And the 10th Amendment was a recognition that we're creating a powerful new national government, one of limited powers, but still more powerful than the Articles of Confederation. The 10th Amendment was about recognizing, even within that system, the states are still going to play an important central role in policymaking in the United States.
Awesome. So Tom, we just went through a ton of the history, a ton of the amendments really quickly. I'm going to share the resources with the students again in the chat, because if you want to dive into this in even more detail, we have lots of classroom materials that you can use. There's a briefing document, the PowerPoint. But when we think about these 10 amendments and we think about how we as Americans kind of group them together, what's the big idea around them? Why do we do that? Why do we kind of package them together? Not just because they were pretty much all ratified around the same time, but there's something else about this listing of rights that we really hold together as an idea and kind of who we are.
Yeah, I think in many ways people are drawn to the Bill of Rights because they're drawn to the idea that in them we're trying to capture some of our most cherished liberties. And so I think that in many ways it goes back to that initial vision that I mentioned of Madison's, which is that the Bill of Rights are designed in part to reflect some of our deepest values, but also at the same time, they're a reminder of our most cherished liberties. And more broadly, Kerry, I think the other thing to keep in mind is that American constitutional history in part is a story about how we turn the Bill of Rights into a true national charter of freedom. And so we have at the founding, it applies only to the national government, but with the 14th Amendment after the Civil War and then later Supreme Court decisions, we then extend many of those Bill of Rights protections to state abuses so that the Bill of Rights truly applies to all levels of government, nation, state, together and broadly.
And I think that's so unbelievably important that we think of the Bill of Rights then we think about that 14th Amendment, ensuring that the Bill of Rights now sticks to the individual. And Colin brought that up and he asked the really simple question, aren't all these modern Bill of Rights cases really 14th Amendment cases? And I absolutely love it. Or they are some kind of in-between combination of the 14th Amendment and the Bill of Rights.
Colin, I love that point. And yeah, in many ways, they are 14th Amendment cases. And that is that what lawyers call, the fancy word is incorporation. But so many of the cases that you care about before the Supreme Court that are Bill of Rights cases in many ways are intimately linked and only made possible by the 14th Amendment.